Good morning. I'm Karen Staffaker, and I'm a member of the Financial Matters and Retirement Committee. So we're excited about today's program. We always have a lot of interest in this topic. Do I need a trust? How does a trust benefit me or my heirs? I added up the collective years of experience, and we're at almost 100 years of experience between the two presenters, and after break, we'll add two panelists. So we want to allow a lot of time for your questions. We always have a lot of questions. So we're excited about today's program. Our first presenter is Joe Meyer. And Joe is Senior Vice President and Director of Wealth Strategy with Johnson Financial Group. He has more than 20 years of combined legal, accounting, and financial services experience. He was formerly with Foley and Lardner, where he led a team of professionals helping clients achieve their financial goals. He has a JD from the University of Wisconsin, a BBA in accounting from UWM. He's a CPA and served as an adjunct professor at the UW Law School. Our second presenter, Park Drescher from BMO Wealth Management, is a regional director of trust services, and he oversees trust administration teams in Madison, Milwaukee, Wausau, and Minneapolis. He is a certified trust and financial advisor with over 25 years of experience. Paul joined BMO Wealth Management in 2017 after working as a senior trust advisor at various financial institutions and practiced law in Appleton. He graduated from Lawrence University and earned his JD at St. Louis University School of Law. So what we're going to do is have the panel first. They're each going to speak for about 20 minutes, and then we will have a 10-minute break. We'll come back promptly for questions and answers, and then I'll introduce our other two panelists. And reminder, please turn off your cell phones or any electronic equipment. So with that, I'll turn it over to Joe.
Thank you. So how's everyone doing this morning? Everyone doing well? Big Packer win? Thank you for that nice introduction. As you probably heard, this is one of the gigs I do is to speak with people like you, which is a lot of fun. The other gig I do is to speak to the law students at the UW, and let me tell you right now, I enjoy this group an awful lot more than I enjoy those kids. So thanks for that. So we're coming off the holiday season. We're starting a new year, and one of those things about the holiday season in Wisconsin is all of us tend to go to some social occasions. We have our old fashions, we stand around, we see people we haven't seen in a while, professional friends, personal friends. And one of the curses of being an estate planning attorney at those events is you get a lot of estate planning questions. And one of the classic questions I always get at those events is, do I need an estate plan? So the way I always answer that question is by first reminding the inquisitive questioner what an estate plan is. And this is one of those things that if you ran a Google search on what is an estate plan, you would probably get a bunch of stuff. And a bunch of stuff would be things like wills and trusts and powers of attorney, and you'd get all these sort of technical jargon terms. But that's not really what an estate plan is. What an estate plan is a strategy. And it's a strategy designed to take care of the people you care about. And the way you take care of the people you care about is you take your stuff and you leave it to the right people, those people that you care about and those people that would maximize their happiness by having that stuff and maximize your happiness by giving them that stuff. You give that stuff to those people at the right time in the right way. That's the nature of the strategy. So when do I transfer property to the right people in the right way to maximize their happiness and maximize my happiness? That's the essence of an estate plan. So the question of do I need an estate plan is sort of a ridiculous question. Why wouldn't you want one, right? Why wouldn't you want a strategy on how to maximize the happiness of the people you care about, thereby maximizing your own. The other thing is an estate plan is a strategy to make sure that the right people are making decisions on your behalf when you no longer can. Now that either might be when you're gone, and of course can't make decisions for yourself, or when you're still here and by law or by just practicality can't make decisions for yourself. When something has happened to you medically where you cannot communicate what you want, or something has happened to your mind, to your so-called, to use the doctor term, your capacity, where you can communicate what you want, but based upon sort of where your mindset is and where your brain function is, your communications no longer have what is known as capacity. You're no longer in your right mind, sort of to use the vernacular. And at that point in time, by law, you cannot make your own decisions. And therefore, either a court's going to decide who makes decisions for you, or you're going to decide who makes decisions for you. And again, that's your choice to make. But for all of the clients and all of the cocktail party patrons who you have that conversation with, everyone is sort of the same. They go, well, if those are critical decisions, and they are, they're critical healthcare decisions, they're critical financial decisions, they're the kind of decisions that take emotional and economic burdens off of loved ones, of course you want to choose the right person or the right people to make those decisions. So do I need an estate plan? That's always the question. The answer is always no, but you sure as heck want one, because these are critical decisions. These are decisions of happiness. These are decisions of legacy. These are decisions of freedom and independence, and I'd rather you made them for yourself because you know the players, including yourself, better than some probate court judge in Dane County knows them. I'd rather you make those decisions because those are critical decisions to make. The other thing that people find interesting, and this is if I've had a couple old fashions before I have the conversation, so I get a little chatty, is I remind people that regardless of whether you create your own plan, everyone in here has an estate plan. And what I mean by that is, we don't live in ancient Egypt, right? Your stuff isn't going to get buried in the ground with you. So when something happens to you and you pass off to the great unknown, your stuff is going somewhere. It's just that if you don't decide where it's going to go, by drafting things like wills and trusts and all of that, the state legislature has decided where it's going to go. Now, maybe that's the right people. A lot of wisdom in the state legislature, right? And maybe it's the wrong people. And maybe it's the right people, but the wrong way. That's a more interesting question. We'll get into that in a little bit. If you haven't decided who's going to make healthcare decisions for you and something happens and you can't, a probate court judge in Dane County will make that decision for you. They might pick the right person. And even if they pick the right person, it's going to be a much more costly endeavor to have that person chosen. I tell you, anytime that you combine these things, by the way, it's a little thing for you to take with you. Anytime you hear something like court proceeding, paperwork intensive, I need a lawyer, it's going to cost a lot of this, right? You're not going to get a lot more value, but it's going to cost a lot of this. And appointing a so-called guardian at that point in time to make healthcare decisions or financial decisions for you is a paperwork intensive, lawyer driven court process. So again, more money than if you made the decision for yourself, and more tragic that a judge might pick the wrong person. So do I need an estate plan? No. Should I have an estate plan? Yes. You should decide how you want to take care of the people you care about. You should decide what is the right property at the right time to the right people. You should decide, most importantly, who should make decisions for you when you cannot. And you do that through executing on that strategy known as an estate plan. We're going to talk a little bit about trusts. And It's always interesting when you talk about trusts and what trusts are and what trusts aren't, and what is a revocable trust versus an irrevocable trust, and when you use one and not the other. So here's what a trust essentially is. A trust is a choice. And it's a choice to say to somebody that I want you to take control over decisions in the future. That person who's going to have control over decisions in the future, that person's known as a trustee. And then you tell that person, here's who I want you to take care of. Here's how I want those choices to work, who I want them to be for the benefit of. That person or those persons are known as beneficiaries. And then there is you, the person who creates, for lack of a better description, the rule book. Here's the rules I want you to apply, Mr. or Mrs. Trustee, to take care of these people that I care about, these beneficiaries. You're known as the grantor. When we talk about a revocable trust, this isn't always the case, but it's generally the case. What we're doing with a revocable trust is we're deciding that there's a simplicity to ownership and a simplicity to transition of assets that we want to take advantage of. We might want to avoid probate. We might want to avoid retitling. We might want to protect ourselves if something were to happen to us in the so-called incapacity realm. We're worried about what if we become incapacitated later on, who manages our assets. And a revocable trust can be a great way to do that. Now, typically with a revocable trust, when it's created, the trustee, the beneficiaries, and the grantor, the person creating the trust, the person in control, and the person who it's for the benefit of, are all the same person. It is you. So you might look back and go, why in the world would I want to create that? And you're not really creating it for anything that is pertinent right now, because we really haven't changed your enjoyment or control of the property that you put in the trust. We're dealing with some later situations. If I pass away, we want to get property to my family as easily as possible. If I were to become incapacitated, I want control over that property to be as simple as it can be. And a revocable trust is a way, it's a tool, it's a pretty effective tool actually, to do those things, to make sure that the right property goes to the right people at the right time in the right way, and the right people are making decisions in your absence. A revocable trust can be a great execution model to get all of that done. Revocable by its very term means that I can terminate the trust or change its provisions. That's what revocable means. I can change my mind. So again, with a revocable trust, we're putting a process in place. We might want to change our mind. We might want to change the players. We might want to change the rules, and we have the ability to do that. Again, it's a design, it's a structure to deal with later situations that will happen, right? We all are going to pass away, right? So we're dealing with that later on. An irrevocable trust is different. An irrevocable trust, again, irrevocable by its very terms means not subject to termination and not subject to change. So when I transfer property to an irrevocable trust, I am literally giving it away. Why would you do that? The reason that people use irrevocable trusts are basically because there is I'm going to use the term penalty, maybe a consequence under the law of owning property that you're trying to avoid. There's a consequence to ownership that you're trying to avoid. And to avoid it, you decide I can give it away to a family member, right? So if I take my property and I give it away to my two daughters are 23 and 20, I can give it away to my two daughters and avoid the consequence of ownership. But when I give it to my two daughters, I love my two daughters to death. As my wife and I tell each other all the time, we raised good, strong, independent women, and someday that'll pay off for us, right? So again, I mean, my kids are great, but they're gonna make some decisions at 23 and 20 that I think might be suboptimal, right? Just thinking about a couple right in my mind, so a couple things, starting to get visuals in my head. Things down on University Avenue in Madison, actually. So I want to give it away because I want to avoid those consequences of ownership. But I want to give it away in a way that they can benefit from it. They're the beneficiaries. I put somebody else in control of it. I pick somebody who I trust as the trustee, and I put rules around it, those things that extend my values and beliefs as the grantor. So I create the rule book around my values and beliefs, what I believe will make them good, thoughtful, strong, mature, happy, fulfilled individuals. I put somebody else in charge of making sure that they, for lack of a better description, run that rule book as I would want them to do it, the trustee, somebody who I trust, and I do it for their benefit as beneficiaries. So what are those negative consequences? Why would I want to give property away? There's really two reasons. Reason number one is creditors. So if I own property and I do something dumb, right? And somebody comes after me and sues me, or not dumb, but I run up a big bill and somebody comes after me for the bill, they can come after me for all the property I own. Let me repeat that. They can come after me and sue me and collect any property I own. What they cannot come after me for and sue me for and collect is any property I don't own. So there's a consequence to ownership, right? I mean, there's a lot of great things about owning things, right? We love when we own things. We love when we own BMWs. We love when we own houses. We love when we own the Green Bay Packers. We love when we own all this stuff. But there's a consequence to ownership too, and that is if I own something and I make a mistake, or if I own something and I owe somebody money, they have the right to those things that I own. They're subject to those risks. If, on the other hand, I don't own them, they're not. So the first thing about transferring to a trust is I avoid that property, and the trust avoids creditors. Now, there's a difference between revocable and irrevocable trusts. If I can get at the property, so can my creditor. So remember a revocable trust, right? The reason we use a revocable trust is if I change my mind and I want the property back, I have the power, I have the legal power to do that. I can change my mind, pull that property back. Well, if I can change my mind and pull the property back, so can my creditors. So if I want to protect the property from people who might do me harm, then I create an irrevocable trust, because then I can't get the property back, neither can my creditors. The other classic reason people use irrevocable trusts is that they want to give property away at a time when the taxation of the gift is cheaper based on the current state of the law than it might be in the future. Right now, we live in a world where, other than the year 2010, which we had no estate tax, if you would have been lucky enough to pass away in 2010, you would have died without an estate tax, which, by the way, anybody who doesn't think George Steinbrenner is the ultimate winner in America, everyone know who George Steinbrenner is? Owner of the Yankees, billionaire, multi-billionaire. If you don't know how much he wants to win, George Steinbrenner wants to win so much that he died in 2010. He died in the 1 year without an estate tax, and the Yankees passed to his two kids without the imposition of what would have been hundreds of millions of dollars of estate tax. That is called a win, folks. But right now, other than the year 2010, we can transfer more wealth to the next generation without the imposition of a tax than we ever could in our history. And the way we take advantage of that, of course, is we have to give it away, and we give it to things known as irrevocable trusts. So that's why we use irrevocable trusts. That's why we use revocable trusts. Those are sort of the consequences of each of them. Because I work for a trust company, because I spent years as an estate planning attorney, people now very commonly, especially when I meet with clients, when I meet with my former clients, ask me, should I use a professional trustee? Should we use a trust company? So, and again, I know I'm at the end of my time. I'm going to get it over here really quick. So let me just give you a couple real sort of simple thoughts on this. Administering, when I was an estate planning attorney, and I would have mom and dad leave property to the kids, we never left property outright. We always left it in trust, okay? We never left property outright, we always left it in trust. And the question would be why? Trusts do two things really well. Number one, they protect people from their own financial immaturity. Because remember when we talked about what a trustee does, they're in control, and what the beneficiaries do, they get the benefit. If I want, right now for a 23 and 20-year-old, if something were to happen to my wife and I, we don't want my two daughters making decisions over their financial future, right? They're too financially immature. So a trust can be a great design to make sure that until they're financially mature, somebody else is making decisions for them. But a trust does something else really, really well. Remember that whole conversation about irrevocable trusts? When I leave property, when Michelle and I leave our property in trust for our children, and those trusts therefore are irrevocable trusts, no matter what kind of stupidity they engage in, right? Think about University Avenue, right? No matter what kind of stupidity they engage in, that property is protected from their creditors, their predators, and maybe most important, given a 51% divorce rate, a divorcing spouse. So I make sure that my property goes to my children as opposed to going to my ex-sons-in-law, okay? So we absolutely left everything in trust. The question then becomes, go back to that role of trustee and what a trustee does. Who should be that trustee? And there is an age when our kids are financially, I mean, just under my plan, there is an age where my kids are financially mature enough to make their own decisions, and therefore when it comes to how they enjoy the property, my kids will be the trustees of their own trust. But there's another consequence to trusts, and you can see the slide up here. When you put property in trust, there's a lot of rules. There's tax rules, there's accounting rules, there's a lot of things that you have to follow and a lot of formalities you have to follow to make them work the way you want them to. And don't create structure that isn't going to work the way you want them to, because that's just called a waste of money. That's just called making lawyers rich, which none of us want to do, right? So again, when it comes to creating trust, you want to make sure they work right, and therefore those rules are followed in a pristine way. A professional trustee isn't necessary, but a professional trustee is a lot simpler, right? Because those rules, they do every day. And those rules, when it comes to, valuing time and the stress we're going to put our kids under if they're their own trustees and have to follow those rules, it's a lot easier, a lot less stressful, a lot more maximizing happiness if we have a professional trustee run that rule book as opposed to our kids. So again, I always tell my clients when they say, should I have a professional trustee? I always say, let's bifurcate the roles, right? Who do you want to make decisions over how your kids enjoy the money? That's one role. Who do you want to invest the property that you leave? That's another role. Who do you want to deal with the administrative difficulties of holding property in trust? That's another role, right? And let's take each of those roles and figure out under your plan and how we maximize happiness, how we execute your values and beliefs, how we make sure that we take care of the people we care about. We want to figure out who should be in each of those roles. So it's not as simple of a question. It's not binary, yes or no. It's how do we structure the governance, which is a fancy way of saying decision-making authority, in the right way to accomplish your plan. I went 5 minutes over. I apologize for taking a little bit extra time. Passing on over to you.
Joe, you're a hard act to follow. That was very comprehensive, and I think your work for the UW Law School really shows. It was a great presentation. So Thank you for having us, and thank you for having me. My name is Park Drescher. I'm the Regional Director of Trust for BMO Wealth Management. I'm here with my colleague Jennifer Ridley Hansen, our Private Wealth Advisor. And what I'd like to do is, Joe's explanations were excellent, and I think set the stage for further discussions on the panel level. So I'm delighted that we've got that background in front of us. So what I thought I would do is just cover a little bit about what the trustees' duties are and provide a little bit of color in terms of administration and some of the legal risks involved in the administration of trusts. So with that being said, as you all know, BMO Wealth Management, BMO Harris Bank is the successor bank to M&I, an M&I trust company. This provides a little bit of information about who we are and how we fit into wealth and trust and estate planning. This is our footprint. The Wisconsin market, of course, is an extremely important market to us, and we are tremendously respectful and appreciative of the legacy of M&I Trust Company. As an overall services, as Joe had mentioned, any corporate fiduciary will also provide a suite of services for estate planning, investment management, wealth planning in terms of financial planning, with you at the center or with our clients at the center of what we do. With that being said, I thought I would just continue along the lines of the discussion of trusts and irrevocable trusts and trust basics, which you've already just heard. So I hope to add a little bit of color onto that. So a trust is essentially, as Joe said, it's a set of instructions to a trustee, a private contract between the creators and a trustee. I think of it as often as a box, and that box has a set of instructions on how assets are put into that box and how assets are removed from that box, as Joe had previously mentioned. The legal responsibilities, these require time and expertise in the administration of a trust. And as Joe said, who is your trustee is a major and important question. The establishment of a trust is control, privacy, protection, preservation, and taxes. And I did want to talk a little bit about taxes, just very briefly. When I practiced and first started practicing law many years ago, the federal exemption amount or exclusion amount was $675,000. So just to back up a little bit, there's an unlimited marital deduction, meaning that when one spouse passes away, you can leave to the surviving spouse as much money as you want without incurring a federal estate tax. Where the Treasury Department gets interested and the IRS gets interested is on the second spouse to pass away. And what has happened over the course of history is that the exemption amount has gone from $675,000 to $750,000 to $1 million to $3.5 to $5 million. And this is an amount we all have. So all US citizens have this federal exemption amount. And as I said, there's no federal estate tax imposed at the first spouse, but on the second to die, that's where things get kind of interesting. And right now, the IRS has recently announced that the estate and gift tax limits for 2020 have increased a little bit. So now the estate and gift tax exemption is $11.58 million per individual, and that's up from $11.4 in 2019. So this means that you can, on a combined basis, a husband and wife can leave $23.16 million to their beneficiaries without incurring any federal estate tax. So this is the amount is grown and grown and grown over the years, and it's important to note too that this is scheduled to sunset in the year 2026, and it will go back down to $5.6 million. And so the question becomes what will happen politically if there is, for example, a change in the Senate or a change in the executive branch, and we have, for example, President Sanders or President Warren that would look at the estate tax and begin to think about things a little bit differently than the current political climate. So it becomes important from a tax point of view to begin to think about planning and seeing where we go politically in the coming years. The annual exclusion gift, this is an amount you can give to anyone, tax-free to the donor, tax-free to the recipient, is $15,000, and in 2020 that will stay the same. So part of any estate plan is thinking about the minimization of federal estate tax consequences. The types of trust, Joe, you covered that beautifully. I won't go into that in too much more detail. The considerations when naming a trustee, one of the advantages of a corporate trustee is that we do not become incapacitated or incompetent. We are there permanently. We have bench strength of professionals that will always be there. I always think of, in a way, as a corporate trustee as Switzerland. We're neutral. We have no duty other than a duty of loyalty and a fiduciary duty, but we take the emotion out of trust and estate settlement. And I'll talk about estate settlement in just a few minutes, but you already have a trust. The question becomes, when was it last reviewed? What are the family dynamics? What are the communications? Who's on your team? And having a team of professionals surround you is tremendously helpful and tremendously valuable. And particularly where statistically we're living longer, but we're living with disabilities such as Alzheimer's or dementia, and it's very important to have a team in place in the eventuality of those life-changing events. Some of the responsibilities that fiduciaries have are the duty of loyalty. The beneficiary's interest must be placed ahead of the trustees. One of the other duties is a duty of impartiality. We have a duty to be impartial to each of the beneficiaries. As I said, we're Switzerland in many instances. We have a duty to avoid interjecting personal favoritism into the decision-making process and in conducting our trust administration. We must make diligent and good faith efforts to identify, respect, and balance the various interests of the beneficiaries. So this is, again, our duty of impartiality. We also have a duty to administer the trust properly, and that is including such things as exercising reasonable care, skill, and caution in a prudent manner, taking into account particular facts and circumstances, operating and administering the trust in accordance with its provisions, which isn't always easy. Trusts and estate planning attorneys are fallible, just as we all are, so there are ambiguities in documents which require construction, and all of these duties are a part of what a corporate trustee does. I took a look at the Wisconsin statutes just to provide. And the Wisconsin law regarding trusts is under Chapter 701. So 701 provides a few things that I thought I would just share with you. Prudent administration under 701-0804, a trustee shall administer the trust as a prudent person would by considering the purposes, terms, distribution requirements, and other circumstances of the trust. In satisfying this standard, the trustee shall exercise reasonable care, skill, and caution. 701-0806, trustee's skills. A trustee has a special skills or expertise or is named as trustee in reliance upon the trustee's representation that the trustee has special skills, expertise, and will use those special skills and expertise. So there are statutorily strict fiduciary duties on a trustee to behave in a prudent and reasonable manner. New tools when naming a trustee. We've talked about a little bit about what professional trustees do. There are increasingly options for irrevocable trusts, and those irrevocable trusts will include the ability to, in some ways, tweak or alter an irrevocable trust under the Wisconsin Trust Code. So the Wisconsin legislature passed the trust code, I believe it was in July of 2014, and it's been up and running now since then for about 6 years. And the trust code is based upon the Uniform Trust Code, which allows the beneficiaries in some instances to reach an understanding or an agreement to tweak or alter the provisions of an irrevocable trust. And that has been an enormously helpful tool in professional trust administration. I refer to them as beneficiary agreements. They're sometimes referred to as non-judicial settlement agreements, which basically means if it's non-judicial, you're not in front of a judge, you're not working with a court, you're working with the beneficiaries directly. And this is a very helpful tool to provide for some flexibility where we've got an irrevocable trust. What's happening in the trust field right now, too, is that there are additional power holders that exist that help the trustee and the family to make certain decisions. Some of them are listed in this slide. Directed trusts, I'll talk about that in just a minute. A trust protector, so this would be somebody that would be named in the document to go shoulder to shoulder with the trustee to help make decisions. So if the trust needs to be altered for tax purposes or administrative purposes, that trust protector can come alongside the corporate trustee or the individual trustee and help to make decisions. A distribution advisor or committee, that's very important. We're seeing more and more language in trusts that deal with addiction, and in particular, we're seeing language about, and with the opioid crisis, we're seeing language about incentive trusts, so incentivizing beneficiaries in a way that is mindful of the fact that we might have addicted or challenged beneficiaries. And a distribution advisor or committee can certainly come alongside a corporate trustee and help in those very difficult decision-making processes. A special trustee or an investment advisor, this relates to, an investment advisor would relate to what is becoming very popular, at least from what we're seeing, and that is directed trusts, where a family would have a special or unique asset, such as a limited liability company or a closely held corporation, where they want a trustee, but they want to maintain the investment advisor powers within somebody that they've worked with for many, many years. And I'll talk about that a little bit later when I touch very briefly on BMO Harris's Delaware Trust Company. Trust and estate services are aligned with your goals. This slide summarizes what Joe and I have been talking about. I'll let you read that on your own and won't go into too much of that, but this is, again, a holistic, comprehensive approach to wealth management. These are the duties we've talked about: a duty of loyalty, duty of skill and care, duty to give notices. That is a increasingly challenging area. We have had and have experienced, because the Wisconsin Trust Code has provided for what's called a duty to inform and report. And the duty to inform and report essentially codifies the trustee's responsibility to provide accounting statements to the next generation. And some of the challenges we're seeing in the field in this respect is we have grantors that are saying, you know, I'm not really comfortable with my son or my daughter receiving an account statement. What are my options? And right now we're, and Joe, I don't know what you're experiencing on this, and we can talk about this at the panel level, but it's possible for a skilled and qualified drafting estate planning attorney to opt out of the Wisconsin duty to inform and report. And so we're seeing documents right now that are, you know, going around that responsibility and that duty in some instances. I've already talked about some of these other responsibilities and duties. Estate settlement services, again, I'm going to let you guys read this at your convenience, but But again, as Joe mentioned, there are all sorts of responsibilities with any estate plan. So that would be a trustee. You would also have a pour-over will with a trust-based estate plan. So that would be, you would have to name a executor. In Wisconsin, they're called a personal representative. And corporate trustees can function in all of these various capacities, both as trustee and as a personal representative. The advantage of that, again, we're neutral, we're objective, we don't have any emotional attachment to the pre-existing family dynamics that might be in existence. And it puts the legal responsibility on the corporate fiduciary. So if you become a personal representative or executive, or as many of you might be aware, if there's a mistake that made, and mistakes are inevitable, mistakes always happen, there is personal liability for the personal representative. And therefore, having a corporate trustee serve as a personal representative removes that personal liability from the individual, from the family. So that's a benefit. The only other thing I would add to estate settlement services is that BMO Harris Bank has a great group of estate terminating and settlement professionals based out of Milwaukee. And we settle and terminate estates all the time and have done this for over 100 years, and we know how to do it and have been doing it for many, many years. The challenges of estate settlement often involve particular family dynamics that surface upon death. And often our responsibility is to navigate those deep waters. So an example would be, we've had instances in which there have been, it's interesting that families will often fight over tangible personal property more than a stock portfolio. So mom had promised me this painting, or mom had promised me this item of tangible personal property. And emotions will get raised, and there are always challenges in post-death administration. So some of the examples I've seen in my history and my experience have been instances in which, unfortunately, we've had to change locks on the family home post-death because people are beginning to converge, and they're converging with station wagons and U-Hauls, and we've seen instances in which, unfortunately, a daughter discovered her father, who had passed away in the night, and then removed items from the house and notified her brother, who lived out of state, about 48 hours after the death. And that is not a good place to start a post-death administration. So very, very challenging. We've seen instances in which there have been fights over paintings and other tangible items of personal property. And so these are all aspects of post-death settlement that we're able to take the emotion out of. So that's part of what a corporate trustee does upon post-death administration. These are the roles and responsibilities of an executor called a personal representative in the state of Wisconsin. Preparing and filing final income taxes, if necessary, preparing an inventory. And again, you only have a probate estate if the main vehicle of the estate plan is a will. So if we've got a trust where the assets, as Joe had mentioned, are titled in the name of the trust, you're able to circumvent probate. And that's very helpful. There's privacy. So probate administrations are a matter of public record, so they're open records that anyone can view and look at. I mean, some of the famous examples that are happening right now is, the Prince estate in Minneapolis, in which there was no estate plan, I believe, and Prince died intestate. So the work that's being done on the royalties and so forth are not easy. So those are some examples of where planning is super, super critical. I've mentioned Delaware very briefly. BMO Harris Bank is fortunate in that we have a group of wonderful folks out in Delaware where the the courts of chancellery in the state of Delaware are so accustomed to working with directed trusts where you've got unique or special assets. So you have a closely held corporation that the family is simply needing a corporate trustee to act as corporate trustee of, and they would like that to be managed by, so for example, we often have some families that have in-house family offices where they have their own private family office and they need a corporate trustee, so they'll name BMO Harris Delaware as the trustee of that document, and then the investment management can be done by the family office. And often we've also seen where there are trust protectors and distribution advisors that are advising us on distribution. So that's one of the unique capabilities of BMO Harris Bank. So one of the interesting components of directed trusts is that they can also hold artwork, for example. So in the state of Wisconsin, we've had a Wisconsin directed trust that holds high value pieces of art, and in that situation, the grantor's son are the directing parties, and as the trustee, we're able to take instructions from the directing parties. So that's an example of the use of the Wisconsin Trust Code. So I'm kind of coming up on my time, I think, here too, and I want to leave enough time for questions. So I'm going to say thank you again. We are so grateful to be here, and we'll be here to answer any questions that you have. Thank you.
What I'll do right now is introduce our two panelists that you've not met yet. First, we have Jennifer Ridley Hansen, and Jennifer is a private wealth advisor with BMO Wealth Management in downtown Madison, and she serves as leader of the client strategy team. She started with M&I Bank. She is a certified financial planner with over 20 years of experience as a financial advisor. Prior to joining M&I, Jennifer worked in the trust department at First Bank, now U.S. Bank in Madison. And she is a graduate of Lawrence University. And we have Ed Kinchy, Senior Vice President, Wealth Advisor, with more than 20 years of wealth management experience. So you can see these years of experience are adding up. And he has the Certified Trust and Financial Advisor designation and is a Certified Financial Planner. Ed earned his bachelor's degree in finance and risk management from UW-La Crosse. So the panelists are going to share the mic, and we are supposed to have two working mics, which hopefully we'll have real soon. Apparently there's an issue with the channel selection on them. And but what we'll do is take questions from the floor, and you can address individual panelists by name, and we're looking forward to the Q&A session. So I'll turn the mic back, the one that's working.
Yeah, I think in general she's asking how financially liable are personal representatives, right? Here's the interesting part about this, right? So I practiced as an estate planning attorney for about 20 years, and you have this balancing act in choosing the right people to make the right decisions. You have a balancing act between, so I will answer your question, I promise, but you have a balancing act between empathy and objectivity. You want people making decisions for you that know your story. And the best people to know your story are your family. And you understand that at times where we're battling over the china, right, or the photo albums, which, by the way, that's going to be a thing of the past pretty quick, battling over photo albums, right? But our biggest battles, his were over art, ours were over photo albums. You know, so you want somebody who can look at things with an objective eye. What we forget as lawyers and what we need to do a better job of, and professional trustees do a good job of it because it's part of our value proposition, is reminding people that there are legal responsibilities fiduciary responsibilities and legal liability to take these roles. So are they forever? They're not forever. Are they longer than you think they would be? They're longer than you would think they would be. And the interesting part is, if you sort of just think about this logically, the reason we use families is because they know our story, and therefore we believe they could step in our shoes and do what we want them to do, which means by definition they take discretion, right? They have fuzzy rules that we trust them to apply in a certain way. The more discretion you take, the more risk there is, right? The more that there's fuzziness in what, if I told you do X, there's no risk in doing X. If I tell you, I generally want you to do what I would do if I were here, there's a lot of risk in doing that. So, yeah, I think that's one place where professional administrators, trustees provide value is they deal with complex processes in such a way that they do it every day and takes that risk off the table.
Yeah, and I would add that if a personal representative or executor is acting in good faith and is exercising prudence in their administration, that is a protection against liability. So the debtor against the IRS would be the estate of your mother. It wouldn't be you as the personal representative, so long as that you're operating in good faith and that you're exercising reasonable prudence in the administration of the post-death administration. Where you get into trouble is where there is gross negligence or there is intentional and willful misconduct on the part of the executor. So I don't know the facts and circumstances, but so long as you're acting in a prudent and reasonable manner, that certainly helps to protect you. So the question was, and correct me if I'm wrong, can you split the roles between an individual trustee and a corporate trustee? And I believe that was your question. And the answer is yes. So for example, some documents will say, if it's a sort of a I love you plan, you know, honey, you're the successor trustee, and if not, then daughter. And the document can provide for the flexibility for the daughter to name a co-trustee to come alongside that individual trustee. And then in that scenario, speaking for BMO Harris and I'm sure for Johnson, you guys are working with an individual trustee in a co-trustee capacity. So that often is tremendously helpful because you're working shoulder to shoulder with that co-trustee. So long as the communication between the corporate trustee and the co-trustee is positive, that's very helpful, very, very helpful.
So you want
I was just going to add, depending on what you're trying to accomplish with the trust, if there's a tax-driven motivation for creating this trust because it'll have some tax advantages or tax savings in the end, oftentimes it's better to have a corporate trustee rather than you or your spouse retain as individual trustee because that creates a more solid case to the IRS that you did not have control over that property and that assets and that you actually do receive the tax benefits and everything that you're trying to accomplish by that strategy. So there are times where co-trustees can be very appropriate and work out great in your situation, but there's also times where it may be more beneficial to have an independent or corporate trustee.
Are there any other lawyers in this room? Just by a show of hands, anyone? Right here? Yeah, so you know what I'm about to say. Lawyers learn how to speak through reading case law, which means that lawyers learn how to speak generally by reading the most ridiculous, arcane, nonsensical language from people in the 1930s. All of you who have dealt with lawyers know that translates, right? Because when you're talking to lawyers, you're going, I haven't heard anyone talk like that since I was 5, right? But they're using these terms that make no sense. So I get the privilege of teaching half of the lawyers that come out of UW on estate planning, and here's what I tell them to your question. Let's get rid of these labels. Who should be trustee? Let's just get rid of that. What decisions need to be made? And who are the right people to make those decisions? So, and remember that when it comes to how do you take care of the people you care about, empathy is critical, right? Knowing what you would do if you were there is critical. Nobody has empathy like a family member. We can get good. All of us can get really good, but what we need to do to get good is we got to know your story, right? So if there's professionals that you are putting as decision makers that don't know your story, we've already got a flawed process. So if you want the safest process to make sure that somebody's going to make decisions over the people you care about that know them, their strengths and weaknesses, that know you, your values and beliefs and your story, it's probably a family member. But then there's a whole other set of things. How do we make decisions between two different people that we care about? How do we, objectivity, how do we deal with these arcane rules that come with managing trusts? How do we invest the property? Those are a different set of people, and probably professional trustees are probably really, in fact, they're really good at it. And then you got the third thing, which we were talking about, which we sort of skated over, which is the whole thing about directing parties, because sometimes you have a piece of property where a professional trustee would be lousy making decisions over it. Think about a closely held business. No one should have a professional trustee running your business. That's just, it would cost too much, and they're not going to do a great job, right? So there you want to pick somebody who knows how to run the business, who can make the critical decisions, and that's a great place where a directing party comes in to make sure that you have the right people making decisions over that. But again, see, here's what lawyers need to do a better job of: explain the why and then start putting labels around it, as opposed to coming in and going, well, a trustee should be this and a directing party should be that again. But that's just our weaknesses, and again, that's part of, we learned by reading cases from 1930, Supreme Court judges with interesting names, so.
In your experience, what's your guesstimate of the age of financial maturity?
It's getting older. It's a great question. So let's go with the statistical analysis, because I probably put together over 1,000 estate plans. And that is a critical question that I always ask to clients and we always talk about. So the classic age is 30. That is getting older. I think, there's something about millennial thinking that probably goes into that, and, experiencing things. And maybe there's even a level of control and different levels of wealth and things like that. One thing that we like to do with our plans when I would create them is stage authority. They used to be, the classic plan used to be when we thought it was a good idea to kick property out of a trust. We'd kick a third out at 25 and a third out at 30 and a third out at 35, or a third out at 30, 35, 40. And the brilliance of that was that people learn best from their mistakes. So if I've got 2 kids that make mistakes. So if we, handed them a third of our property at 30 and they blew it all on a nice BMW and go into Vegas, maybe they learned something, and by the time they were 35, recognized the value of property. You can do that with keeping property in trust as well. We can give them financial authority over decision making with a third of the trust when they're 30. See how they do with that, and then stage in their authority at 35 and 40. But those classically are the ages, 30, 35, 40. And again, in my experience, it's getting a little bit older than when I started practicing.
I think the flaw, from an administration standpoint in carrying out the terms of the trust with the, attained age type of approach is, you guys know your children, you know your beneficiaries, you know the choices that they've made in the past. And the reality is, just because you hit a certain age doesn't mean, woo, I'm financially responsible today. We've all seen friends or children or people, if you're not financially responsible at 35, chances are you're not going to be financially responsible at 40 or 50 or even 70. And I think as we look in the world that we live in today, the bigger issue that we're seeing more and more is protection. Creditor protection, divorce, substance abuse, all these issues that it doesn't matter what your age is. If you're going to get sued, your assets could be in jeopardy. And then where's the protection in that? So I think we're seeing a little bit more of a different mindset and a different approach to the standard attained age. Here's half your inheritance. What I tell people that I'm working with is ask yourself the question, these are your assets, right, that you're leaving behind. At what point would you feel okay if they just blew it on, candy and bubble gum? Because that's the real question. If they blow it, it's gone. And, where will they be then?
So just one additional comment on that. As we're working with our clients, a lot of times this age of distribution does come up. I think for some parents and grandparents, the concern is you give the kids all this money at 30, what's the incentive for them to keep working and have a career? So I've seen some clients push out those dates further or give them smaller amounts or percentages. I've seen a trust where beneficiaries don't get anything until they're 60. And it's because the parents wanted those kids to get an education and get a job and learn the value of hard work and what goes into creating those assets. And so I think a lot of it depends on the family, but we've definitely seen that change over the years where maybe it used to be 20-something, but then again, some of those kids, I've heard clients say, I don't want my kids to get wrecked by the money and literally have no incentive to work whatsoever. And so that's also a concern we see quite often.
Just a real quick question. If I understood you correctly, you can have both a revocable trust and an irrevocable trust. Is that correct?
Yes.
Yes. There'd be different reasons why you'd want each, and sometimes they actually work together, and sometimes the revocable trust creates an irrevocable trust upon death, and so sometimes it may not be two separate documents in the beginning, but certainly there's a lot of flexibility there, yes.
And I don't know what your opinion on this is, but I've administered accounts in which there are dozens of trusts. There are grats and grits and no more grits, but cruts and so forth. So,
yeah, it's kind of intuitive. The larger the estate gets, the more complex it gets, and really a trust is just a vehicle to accomplish a certain goal or objective. And so when you have really large estates, you're typically going to have many different trusts that are designed to accomplish different things. If we talk about, wealth transfer, you're still alive, but you're wanting to start to transfer some wealth to that next generation. A lot of times you do establish an irrevocable trust with specific rules and guidelines on how the funds can be used. But you're trying to, shift that wealth to that next generation. So that's a specific purpose.
Can a married couple have separate trusts? And the answer is absolutely you can. Let's talk about Wisconsin law. Wisconsin is the only state outside of the West Coast that has what we call marital property, what everyone else, because we have to be unique here, calls community property, which means that I think it's always easier to start with other states. So if you were in Illinois and you made money, it's your money. If you're in Illinois and you have the title to your BMW, it's your BMW. If you live in Illinois and the house is titled in your name, it's your house. Your spouse has certain rights. Those kick in upon divorce. Or they kick in if you pass away and decide to leave something to other people. But that is your property. The nature of your spouse's rights are rights. So if you do something else, they have rights to undo it, for lack of a better description. Wisconsin's different. When you guys make money and you're married, it is half your money. When you own property in your name, generally, it is half your property. When you have your BMW titled in your name, it is half yours. So can married couples create separate trusts? Yes, they can. Given the nature of how property rights work in Wisconsin, generally, and again, generally, we as estate planning lawyers would create joint trusts because it becomes simpler given the practicalities of marital property law. So the answer to your question is absolutely. Are there reasons you would create separate trusts? Absolutely. You want different things done with different property when you pass away. There's just complexity in the administration of the estate, given the realities of community property law.
The question was, may I, as the grantor, create a revocable trust now that I'm managing, I'm my own trustee for it, and then upon the event of my incapacity, then a corporate trustee would take over the responsibility of the trustee, if I understand the question correctly. And the answer is absolutely yes. And all trusts are different. So what is the standard to judge incapacity differs from document to document. We've seen examples where there is a disability committee, where there are various family members that are empowered with the authority to make that determination. Most likely the default is a physician or psychologist who is unrelated to me by blood or marriage makes the determination that I am no longer willing to manage my financial affairs. And within that, the corporate trustee would look for a statement of incapacity from that physician or psychologist that would verify the incapacity. Physicians, in my experience, are more likely to sign off on an incapacity with respect to healthcare decisions than they have been with financial decisions, but they do that. So the standard of incapacity is just as unique as you are.
So just one thing I would add to that, one reason why you may want to consider doing that, so this would be setting up your own revocable trust with you as a trustee or as a married couple with the two of you as trustees, is that the assets in the trust that are retitled would then avoid probate. And so I think that's an important consideration. We talked a little bit about probate earlier. If you've got the money in your own name or in a different title right now, and you were to pass away, likely those assets will go through probate. So again, setting that trust up now with a backup trustee to come in down the road to help manage your affairs is really a great idea. So we would encourage you to take those steps.
I would just add, I think sometimes the challenge with that, if you become incapacitated or you pass away, and then all of a sudden a corporate successor trustee, corporate or individual, is coming in to the ballgame at that point, because they haven't worked with you, because they don't know what your desires are other than just reading the legal document, it can often be more difficult to administer that, especially if there's children or family involved in trusts that are created on the back end, because we don't know you. We don't know what you're really trying to accomplish. All we can go off of is the legal document that we can read in black and white. But sometimes that does raise some challenges, as opposed to many clients that I've worked with. I've worked with them for 20 years, and I know them very well. I know their family. I know what they're trying to accomplish. So when that event happens, it's already, in my mind as far as what the plan is and what their desires are.
Two questions, totally different. First of all, there was one slide that you did not get to, which was the trustee compensation. Could you explain what that slide means, number one? And then number two, and also at what point fees would kick in either when a trust is ongoing cost to having a trust before anything, before you die. The second question then is about taxes. If items are in a trust that incur taxes, like a house, investments, whatever, do all the taxes end up getting reported on your personal income tax statement? Are there some things that would be reported actually by the trust itself and paid by the trust? And this is all before you die. Okay.
So I'm going to let Ed take the fee question because it's the harder one, and I get the benefit of being the speaker, so I can pass it off. The answer to your question is more complex than it should be, right? Because it's in the tax code, and the nature of the tax code, it's more complex than it should be. Because it's written by lawyers, right? Most people who go to the legislature are lawyers, and we talked about how lawyers are complex human beings with the way they talk and think. So, but the answer to the question is it depends, which is a classic lawyer answer. It depends on whether it's, first of all, if it's revocable versus irrevocable. If it's revocable, it's very straightforward. It is your responsibility. So from an income tax standpoint, when you take property and you transfer it to a trust and you have the right to revoke the trust and you are indistinguishable from an income tax perspective. So whatever responsibilities the trust has around taxes, you have. If it's irrevocable, that could still be true. If you create an irrevocable trust in a way that you decide that you still want to be responsible for the income tax burdens of the trust, you can do that. In fact, as estate planners, we probably do that 80% of the time. And the reason we do it is, if you think about one of the main reasons that we create these trusts is to give away as much as we can with as low of a transfer tax burden as we can pay. One of the great ways we can give away more is that when the trust runs up a bill that has to be paid, we pay it, right? So there's a lot of reasons why, even with irrevocable trust while we're alive, we continue to be responsible for the income tax burdens, but we don't have to be. We can design the trust so that the trust is responsible for its own income tax burden. The challenge with making the trust responsible for its own income tax burden is that trusts go up to the top bracket like that, at about $12,000 of income. Whereas human beings go up to the top tax bracket, I don't even know what it is anymore because I haven't looked at those brackets for a while, but it's got to be $1 million of income. So it's a dramatic, you're going to pay way more in taxes if the trust is responsible for the taxation as opposed to individuals. Another reason, right, why we keep the individual responsible for the income tax burden. And I'm going to let Ed talk about fees.
Funny how the attorney doesn't want to talk about compensation, right? So in our slides, I did include, our fee structure at Johnson Bank, but in general, most corporate trustees, I can't say that all, will have an asset management-based type of structure to where their fee, for the most part, all-inclusive, their fee is based on the value of the portfolios or the value of the trust that they're managing. It may be in $1 million increments or 2 million or something like that, but it's typically going to be a certain percentage based on this value of the asset. And it's typically going to be an annualized fee. And like anything else, I think to a certain degree, you get what you pay for. It's easy to just shy away from a corporate trustee because you think that they're expensive or the bank is just out for your money. And that's really not the case. Like any service, you're paying for, the investment management of those assets because they have a certain specialty in investing those assets or administering the terms of the trust that can often be very difficult, especially when there's multiple beneficiaries. So, you are paying for a valuable service and different entities are going to have different percentages, but for the most part, they're going to be based on the value of the assets that they're managing.
But just one question there. When you mention the assets, you're talking about financial assets. What about a house? When you figure out exactly what the fees are, do you include the house in the value of the asset?
That's a good question, and it gets a little bit gray because oftentimes it depends on what is our responsibility and what are our duties associated with that house. If the house is in the trust for titling and probate type purposes, but the grantor, you're still living there, you're taking care of the lawn and the snow removal and the maintenance and everything, the trustee's not doing that. We typically just have a flat parcel fee. Maybe it's $350 or $250 to make sure the property taxes are paid, make sure it has insurance on it, the right level of insurance. But, the bank isn't, out there. I'm not out there shoveling your lawn shoveling the snow this past weekend. So that doesn't necessarily get included in the market value when we're making that total fee calculation.
So I think one part of the question also was, when does the trustee start charging fees? And so I think that, again, I believe is similar between both institutions. So we don't start charging a trustee fee until the day we take over as trustee. So we could be named in the document. We're basically there kind of on standby, waiting for an event to occur. And it could be incapacity. Sometimes we find that clients voluntarily say, I'm not really tracking. I feel like I'm missing things. I don't want the responsibility. I want to enjoy my retirement. I want to travel. I don't want to deal with my assets. I want to delegate that to a professional manager. And so that's sometimes when we do come in as trustee. The other thing I would say is that we oftentimes work with our clients to help them get the estate plan in order. So even if you have a trust or you don't have a trust, to really do that upfront planning to think about the family dynamics. Think about what kinds of things you want to include in that trust. Think about the ages for distributions. Think about your grandchildren and your charitable intentions. And so doing that upfront consultation, we don't charge for that service. So we don't charge by the hour to sit down and talk with us just to get some ideas on paper. And then you would meet with an attorney to draft the documents. So we don't draft any documents. We can recommend attorneys that we work with at Madison that we know do a really good job, charge a reasonable fee. So again, that part of the planning is something that we would do. The other thing I'd say regarding the asset management is that currently, whether you have an advisor or whether you're managing it on your own, there's still a cost to own an investment. Unless you're holding stock certificates in paper form, then there's probably no real cost. But if you have a mutual fund, there's an internal fee. If you have an advisor, there's some type of fee. So I think when you go from another provider or managing on your own to working with an institution, you realize that you're already paying some kind of a fee. And so I think for some clients, it's not so much going from 0 fee to a 1% fee. It's going from whatever it is currently to maybe a higher fee potentially. But again, oftentimes you're hitting those break points. So we have a similar fee structure where over the first $2 million, the fee actually goes down. So the more managed money we have for the client, typically the lower that fee would go.
From experience and coming from a large family, when my parents became older, sister and husband moved in, took care of them. And the rest of us 6 siblings thought that was great. But we found out later, the trust, everything was changed to just them. And so I guess I'm speaking for just FYI. I don't know how, I hate to see other families go through that. And then we wanted a copy of the trust, and we were told we couldn't get it because we're not in it. So just FYI.
More than anything else, sibling relationships seem to offer unique challenges. So that said, if you have any kind of fiduciary duty over assets that other siblings are the qualified remainder beneficiaries of, you can breach that fiduciary duty. And if you've breached that fiduciary duty, you've opened yourself up for liability. But the challenge of that is, who wants to be a plaintiff and a defendant against a sister or brother? And these are very challenging issues that when you're talking about family and money, the challenges just multiply exponentially.
First of all, I'm sorry, right? I mean, it's tough, right? That's why estate planning is so critically important, because you're taking money and family and you're mixing it up in this weird soup, right? This weird stew. And the challenge is this stuff always comes to bear when mom and dad are gone. And we don't know what their story was. And, there's, as I'm sure somebody's told you at a cocktail party, or you've Googled it, or maybe you've talked to an attorney, there's an area of law that covers this. It's called undue influence, which sort of is what it sounds like, which is, at its worst, your sister and brother-in-law took advantage of the fact that they were close. As I always tell my law students when it comes to undue influence, there's a presumption, which is a fancy way of saying if in a 50-50 case you lose, right? That's a presumption. There's a presumption that your mom and dad knew what they were doing. And so you got to get beyond that presumption. And then I always joke with them, because we always get the benefit of reading the cases. And I say, we really don't have to read any of these cases of undue influence. What we have to do is we have to go get a subscription to Disney Plus. And we've got to go back to all those 1930 Disney movies. And we've got to find out who the villains were. And if we have those villains, we win. So the evil stepmother, win, right? So Cinderella, we got to win. Snow White, we got to win, right? Cruella de Vil, we got to win. But eventually, when it comes down to siblings, it's a lot less clear. And, in this world of, all things being equal, do we think your mom and dad knew what they were doing? A judge is going to go, unless you can prove they didn't, they did. And so again, as I always told my clients, I need to know what your values and beliefs are when we put together this plan, and I need to know, I have one threshold question. How important is it to you that when you're gone, your family still gets together for Thanksgiving dinner? That is my threshold question in preparing this plan, because whatever you do, I am going to now be your mirror and say that you want to do this, that's going to ruin Thanksgiving, right? That's one of my roles and one of my responsibilities. Because again, estate planning is not about equality. Estate planning is about maximizing happiness, and you need to help me understand your story so that I help you do that. So again, I feel for you. It's not that we've all dealt with these things, and it's awful being in a world of not being able to talk to mom and dad. That's probably the best piece that I can tell you. I feel for you.
Yeah, so I think if we heard correctly, how do you go about finding a corporate trustee and what that process is? There's a lot of corporate trustees in this area and nationally. I think you interview them. Go talk to the people in the bank, people that are sitting up here. Ask them your questions, tell them your story, and find out, how they would handle your situation. We're people as well. We've been in the business, X number of years. And I think whoever you're working with, no different than if you're trying to find a doctor, you want to have somebody that you can trust sitting on the other side of the table, knowing that, yeah, they get me, they understand what I'm trying to accomplish, and I feel comfortable with this person that they're going to carry that out. If you don't have that trust, move on. Move on and interview somebody else until you find that, because once you're gone or something happens, you're relying on that other party to carry out your wishes and your desires. Just like us being the bankers, so do attorneys have other relationships with corporate trustees? Just like us as the bankers, we don't draft the documents, but we've worked with a lot of lawyers throughout the area in the estate planning business, and we know, their experience and can refer. It goes both ways. I think attorneys out there that do not act as trustees, have worked with various banks and other institutions to where they feel comfortable referring their clients to Johnson Bank or BMO or whomever. There are some law firms where individual attorneys will act as trustees. So it varies, I think, from firm to firm and what their policies are.
Sure, yeah. And I think it can kind of start either way. So I think part of the question was, do you go to the attorney first and say, who do I name as trustee? Or do you go to the bank first and say, do you want to be my trustee? So I think it kind of goes both ways. I think if you know an attorney, and I think sometimes your friends and people that you know may have a relationship with an attorney that they would highly recommend, someone who did their own estate plan. So maybe that's also a place to start, talk amongst yourselves and see who everyone else worked with and whether it was a good experience, whether they felt like they got what they wanted, and whether they felt like it was a fair price. I mean, we've seen people overpay for a trust document that's, this thick and doesn't really address the concerns. And so I think that's part of it is you do get what you pay for, but I think you can also overpay for something that's way beyond what you actually need. And so I think if you have a relationship with a bank that has a trust company, you might start there. I think there's some convenience. You already have a relationship with the institution, and you can just learn more about the services. So I think you can kind of go either way. And I think what you'd eventually come to is a comfort level, again, where the attorney seems like the right fit for you, and you feel like you're going to get a plan that addresses all of your concerns, and then you find the right corporate trustee who has all the administration capabilities to really handle your plan.
So I've done both, right? 20 years as a practicing attorney, and now I'm here. Here's what I would say to you. You should interview lawyers the same way that you interview. Ed's answer was perfect, right? You should interview lawyers the same way. Because as we talked about over here, estate planning is this magical combination of your values and beliefs and how your values and beliefs are extended through your property to take care of the people you care about after you're gone. If you feel like you're being treated as a checklist, and I'm seeing nods already in the audience that people have put their estate planning documents together and they're asked 5 questions and then they say, I'll send you the documents. I would make sure that that's what you want the story of your assets to tell after you're gone. If on the other hand, you have an attorney who goes, you know, tell me about the people you care about, tell me about your property, tell me how they work together, tell me about whether your values and beliefs are more important than their values and beliefs. What are those values and beliefs you want to make sure get extended to the next generation? You know, my gosh, if they actually say what are the strengths and weaknesses of your kids and what makes them happy, like I almost think no lawyers talk like that, but if they do, they're extraordinary. That's the kind of people you want as far as, and that is why, again, I would say that we're all wired to have that kind of conversation first. So again, I'm a completely neutral party. I love lawyers, I train them, right? I was one for years. We're really good just by what we do at getting to the heart of the matter, getting to your story, for lack of a better description, and I think your story is important. So if you were to come to somebody like us and tell your story, and then we were to help you find the right person to take that story and put it into words, I think that might be, I might think is the better process, as opposed to going to somebody who asks you 5 questions, now you put it into words, and now you come to us and go execute that story, and it's not really your story. It's the lawyer's story, right? So again, that's just my advice for what it's worth.
A couple of questions, both kind of related to ones that have already been asked. But the first one is about what you were just talking about, and you're coming from the attorney perspective. The lady over there was coming from the family perspective. That's assuming things don't change. And even though you may have a relationship with an attorney, the attorney still needs to be practicing and remember everything. And that isn't always a given because we don't know when our story is going to end. We don't know any of that. And that's a really tough thing to have happen. The family dynamics also change, and the effect of emotion and grief plays a very big role in what happens at the end of all of this. And from what I have seen among almost universally, is that somebody's going to try and take something over. I've seen that almost universally, where somebody decides, no matter how good the plan was laid out, that they have a better idea. And they're going to do whatever they need to do in order to get this accomplished. And that's some pretty harsh reality. So any ideas on protections for that? I know you mentioned the trust protector, some of those things, because for me personally, that's probably my biggest concern, is that even if you have a plan that you make when you're of sound mind, I don't know where my story is going to end and what kind of situation I'm going to be. And I know how I feel about things, but I need to have somebody that can be my voice when I'm no longer either physically or mentally able to do that, and then later on to be my voice from the grave. And so that's really critical. So that's the first part of my question. The second part of my question goes along the line of taxes and whether you should name the beneficiary as the trust itself, and particularly with respect to taxes and the effect that some tools like the use of a K-1 to distribute among beneficiaries and what it has on that.
I'll tackle the first question. I don't know if I'll repeat it in total, but I think, the bigger the family gets, if you will, the more complicated it gets, right? Because there's more people involved. Everybody has their own views and thoughts and, ideas. What we often do sometimes, if it's the right circumstance, is work with the family. If you're working with mom and dad and their estate plan, at what point does it make sense to bring in the children and have a conversation on what the plan details are, so that everybody is on the same page. They know what mom and dad's intent is before it's too late and they're gone. Because we all know once they're gone, we don't know what the mindset was or what they're really trying to accomplish. So it's never too early to start the conversation. That doesn't mean that you have to get down to the exact penny or all the details, but to have the entire family in on, kind of the overview of the plan, so that if, hey, 5 years down the road, the plan changes, okay, everybody knew what it was on the front end, why did it change to what we have now? And then you can hopefully address the issues. So maybe it's not right for every family to bring them in and at what time. It's kind of a gut situation. You have to know when it might be right. But oftentimes we do work with the extended family, bring in the children so that everybody's aware of what the plan is and what mom and dad's intentions are.
My experience would be that there is not any perfect estate plan, and that those families that communicate with each other and are healthier in terms of their communication flows have a better chance on post-death administration than those families, and there are always secrets in families. So, and somebody mentioned the word grief, and grieving does affect post-death administration. There's no, in my experience, it does. So those families that are able to communicate in advance and have an ongoing review of this is how this is going to unfold when there's a death or a triggering event, they have the highest likelihood of surviving intact the post-death administration. So that would be my observation.
So again, I teach law students in the law in this area, right? So I know this is surprising because, you always hear about the exceptions. The law is designed to bend over backwards. Regardless of whether your system is fair, equal, right, wrong, or indifferent, the law bends over backwards so that it's your choice. With that in mind, the more ways that you can communicate the why behind your what, the better it's going to be. Probably for the last 6 years that I practiced, we talked a lot about wills and trusts and powers and all that. The most powerful document that we used wasn't any of those things. It was something called a family mission statement. And a family mission statement was simply I shouldn't say simply, it was probably about a 4-page letter that said, here are the things that I believe in, and here's the people I care about, and here's how I'm tying the two together. So I believe in independence, for example, and therefore we're not going to make distributions until the kids are 60, because I believe in that. I believe in this case that I believe in loyalty, right? And I'm not saying this is the case, by the way, but these people showed me loyalty by moving in and taking care of me, and therefore I'm going to care for them. At the very least, we know your story, right? We're not happy about it. We're not thrilled about it. We're hurt. Ever since Cain and Abel, right? Parents are wired to hurt their kids. Kids are wired to hurt their parents. But at the end of the day, at least it's your story that's being told. You asked about trust protectors. It's another great way to get your story told. Whoever that is, right? If that's your sister, if that's your brother, if that's your best friend, if it's whoever, giving that person the power to make decisions in the future, which are designed to be, what would I have done if I was here? Having somebody you trust implicitly that knows your story is a great part of an estate plan. Do I recommend it? I highly recommend it. There's a weakness. That is, that person has to know your story, right? But if they know your story cold and it's somebody that you trust implicitly, that you believe would make the decisions you would believe for the reason, make the decisions you would have made if you were here for the same reasons, I think it's an incredibly powerful part of an estate plan. We all know the weakness of estate planning is when we have unanswered questions, we don't have the people here to answer them. So the more answers you can give at that point in time on here's what I believed, here's what my stories are, here's what I value, here's what my emotions are and were, I think the better the plan. When it comes to taxes, here's what I always tell clients when it comes to should I own it in trust, should I not own it in trust, what are the tax consequences of doing so? We don't live in Sweden, okay? So, and by saying we don't live in Sweden, we don't have a 95% tax rate, right? So there is nothing more economically painful. There's nothing more that will switch the ownership of an asset from someone you care about to somebody that you don't want to have it than a creditor or a divorcing spouse or a predator. So do I believe in trust as a way to protect the asset itself and protect the people I care about? I do. Do I think that having a team in place that understands how to, I'm going to use the term because I don't think the IRS is here today, manipulate the tax code? Because again, somebody, we don't want to have properties of the federal government as opposed to family, so do I think it's important to have the right team that understands the tax code and can manipulate it to maximize the property that's in the hands of the people I care about? I do as well. Did that answer your question, that second one?
Well, I think it's more on naming the trust as the beneficiary.
Yeah.
More for convenience purposes, rather than having to go to a variety of different, say, investment options or property options or things that require the individual beneficiaries, and just making sure that you haven't missed something by naming it in your trust, where it's always, one consistent, and then you've got your trust set up with your beneficiaries, and it's like, this is how it's going to be.
Yeah, so I would still have the same answer I had before, right? So I'm still a believer of, because we just don't know what's going to happen with the people we care about, stuff happens. I always would use a trust as the beneficiary because it protects them from creditors, predators, and divorcing spouses. I also think it allows you, I think your point's very savvy. It allows you to tell your story one time and to have that story apply to all of your assets. So if you think about bringing all your assets together so that you can tell one story about how you want to use that property to take care of the people you care about, I think that makes a lot of sense to me.
Okay, we have time for one last question.
Great question. To paraphrase the question was, if you create a Wisconsin-based trust and you move to a different state, do you or should you create a new trust under the state in which you are then residing? And the short answer to that question is there are two principles that I would suggest we think about in terms of administration, and that is the principal place of administration. Where is the trust being administered? And the answer to your question is a little bit more complex than I'm prepared to go into right now, but in general, the principal place of administration is where the trust is being administered. So typically, if a trust is created under Wisconsin law, the situs of the trust, where the legal situs of the trust is Wisconsin law. And therefore, the question then becomes, if you were to move outside of the state of Wisconsin, does it make sense to create another trust with the law of the residence or where the principal place of administration is? The answer is sort of, it depends, is my answer on that one. But there are tax reasons for moving trusts from state to state. All of the states have different state-by-state rules and regulations regarding the governance of trusts. So it depends upon, is the intention of the grantor to be a permanent resident of that state? So if you move to Florida, is your permanent residence going to be the state of Florida? There are income tax consequences to where a state or to where a trust is administered. So, for example, Illinois has a fiduciary income tax to trusts that are administered in principal places in Illinois. So in general, the answer is all sorts of, it depends upon the intention of the grantor and what the long-term goal of the grantor is. So I would answer that by saying, if the intention is to reside in that state and live there permanently, there are justifications and reasons for redoing an estate plan so that the situs of the trust is the governing law of the state in which you are residing in.
That was a really good answer. Do you have to? No. If you're saying, I want this trust to work the way it originally was designed to work. Do I have to go see a lawyer again? The answer is no. Most of the places you're going to want to go just by weather, you want to have a conversation because the laws down there in a lot of these things are way better than the laws up here. So again, it's my first slide, right? Do I need to do it? No. Might you want to do it? Yeah.
Hey, I'd like to thank our panel and give them a round of applause. And we have a lovely portfolio for each of our guests.
Yes, thank you.
As a thank you. And I'd also like to thank the two organizers, committee members that were not able to be here today that worked very hard with our presenters in getting this all set up. And that's Faisal Kayoud and Rick Deluge.